There are two very substantive changes in the contract. One, a change to the claims procedure, and the other, a change to the final account position. But there are other changes of significance. Background information. Again, on the website, when they introduced this change, we were told that greater clarity is given to the position regarding background information. And in fairness to this change, it is probably simply a clarifying amendment. But the amendment has come about by the introduction of a brand new clause, 1.10, which provides us with a definition of background information and tells us in no uncertain terms, as has always been the position, there's no massive change here, that unless the contract tells you that you can rely on a piece of information, you must not rely on it. No warranty is given in relation to it. Nobody is going to stand over the accuracy of anything that is provided to you or anyone on your behalf as background information only. So just be very alert to this. The thing that surprises me about this particular clause is the almost panic-stricken language that is used in it. And I can only conclude that it's come about as a result of some fairly substantial claim where somebody has managed to exercise reliance on information which the contracting authority never intended they should. So we have language which says never under any circumstances, for any purpose whatsoever, can you rely on anything we tell you or anything we give you in any circumstances whatsoever, unless we specifically say that this is a document you should rely on. The language is quite purposeful and is interesting. However, I don't think it really changes the position that had gone before. One thing I would draw to your attention, you can't in any contract say, introduce an exclusion clause, the purpose and effect of which is to deprive you of any obligation under the contract. Exclusion clauses are construed very, very strictly in law against the people who put them into a contract. So if the intention behind your exclusion clause is to literally diminish your contractual responsibility to a negligible extent, then you won't be allowed to rely on that exclusion clause. There are a couple of cases quoted there which are specifically on that point. But if the effect of this background information exclusion clause, which is exactly what it is to say, I want you to do this piece of work for me. I am going to comply with these various obligations, but even if I don't comply with my very key obligations, I won't have any liability to you whatsoever. That's not possible. You can't get away. You can't exclude full liability for your contractual obligation. So it will be of interest if anybody ever gets to look at this exclusion clause in a court, how it might be interpreted. But for practical purposes, I think really rely on nothing unless you're actually told that you specifically are entitled to rely on a contract document. The two very significant changes to the contract, new clauses 10.5.3 and 10.5.5. I said earlier that the contracts had introduced a very new and very difficult claims procedure. That claims procedure is completely condition precedent. If you don't comply with the notice periods in your individual contract, and I always use the building contract or employer design as the template for dealing with this, it says you have 20 days to notify of an event which might result in an adjustment to the contract price or the contract time, and having given that notice, you have a further 20 days within which to provide full detail. Clause 10.5 introduces another one, okay? On the website, we had a one-liner telling us what this was about, which says, disputing on an employer's representative decision has a finite period. Okay, so it's effectively the determination of an employer's representation, of an employer's representative's decision has a finite period. That's what we were told on the website. What this in effect means is that if you submit anything to the employer's representative for decision, he has 20 days within which to make that decision. If he doesn't make the 20 days, the decision within that 20 days, he is deemed to have rejected it. Okay? If he has rejected it, you then have a 28-day period within which to refer that rejection to conciliation. And if you miss that deadline, you're gone. You cannot do anything further with that particular claim. It's a very substantive change. It will have immediate impact on any contract in which it applies. And I would suggest that everybody checks whatever contract you're working on right now. Are you on version 6 or are you on version 7? If you're on version 7, which is for any contracts introduced since July of this year, this will apply to you. Okay? So in addition to your 20 days notice period, 20 days to provide the detailed information, the employer's representative now has 20 days to issue you with his decision, and if he doesn't, he has rejected it. And you then only have 28 days to refer the issue to conciliation. It's substantive and it has practical day-to-day effect and immediate effect. Second very substantive change refers to your final account. Sorry, the effect of this particular one will be both positive and negative. Obviously on the negative side, it's going to increase your clock watching on site. It is really going to impact on your day-to-day management and operation of the site. On the positive side, it is actually going to result in issues being dealt with now rather than being rolled up into a final account discussion and negotiation. It should increase cash flow. It should allow you to press the employer's representative for a decision rather than sitting and waiting for the employer's representative to come back to you. This will allow you to apply pressure in respect of legitimate claims, and that can't be all bad. It is going to be a pain in the neck dealing with it, and it is going to be a very significant downside if you miss these deadlines. I'm not going to underestimate that, but it should, in this particular market, result in an increase in the flow of money. It should, if it's operated properly. Final account. Again, the purpose of this is to try and bring finality to your final account discussion and negotiation within a very defined and tight timeline. In the bulletin, we're told that tighter provisions have been included in the time to submit the final statement in order to comply with the original intention. And again, I understand that the reason for the introduction of this is to bring your final account discussion and negotiation to a conclusion within a defined and very, very, very tight timeline. As is the case with this entire contract, the default position is to the advantage of the employer. So it places the burden on you to do your job, get your account in, get all your ducks in a row properly and in time. Because if you don't, the consequences are very serious. And this particular clause says, and it's a new clause, it's 11.5, if no final statement is given within the time required, and that is 2 months from practical completion, the employer shall be relieved of all liability under or in connection with the contract. And that's a fairly serious consequence for getting it wrong. This puts the onus on you to make sure that your final account is in the place it should be within the time it should be there. If you miss this deadline, according to this clause, which we have to take at face value, the contracting authority is relieved of all obligation to you under the contract. It's a fairly serious consequence for missing a deadline. And I think again, it should be taken on board immediately and urgently by contractors.